Welcome back to the Noble Forms tutorial series on trust administration and probate. In the last video, we showed you how to prepare the date of death spreadsheet. In this hypothetical, John and Jane had a joint trust. Jane is the first to die, and we've prepared a date of death spreadsheet that shows all the assets that she owned and the value at date of death. What administration really has to be done in a joint trust like this? The first thing you're going to want to take a look at is the trust agreement itself. And that's what's on the screen right here. And this was prepared, by you in the estate, the estate planning part of the case. So if you go back to take a look at the trust, you see what happens upon the death of a settler. The trust is to be divided into two shares. The decedent's share, that would be Jane's share, and the survivor's share, that would be John's share, right down here. And you're directed to look to Article 8 to see what to do about the decedent's share. So if you look at Article 8 and see what it says, it talks about the distribution of the personal property to persons designated in a list. Well, if they have a list, then John, as the trustee, would distribute that personal property to whomever. In the absence of a list, the default is that the survivor's trust is the recipient of all the personal property owned by the decedent. The decedent's half of the personal property. Now, if there's any taxes or expenses that are owed, they would be paid at this time. You'd look to see, well, in this case, the specific distributions. If John is the first to die, well, of course, John wasn't the first to die, Jane was, so there is no specific distribution at Jane's death. So the trustee doesn't make any specific gifts at this point. So then in 8.6, it goes on to say that after the payment of all the distributions of the personal property, the taxes and expenses, the specific gifts, the balance of the decedent's share, of Jane's half, shall be distributed to the survivor's trust to be applied and distributed as provided in Article 9. And there's a proviso that John could disclaim the gift from Jane, and if that were the case, then a distribution would be made to a newly established disclaimer trust, and it would be administered pursuant to 8.7. An important first step is to have the client sign an attorney fee agreement, and typically this would be sent to the client with a letter. It could be an email, but it would look something like this. Here's how you do the letter. You go to the Trust Administration app and click Review and look at Documents and do Initial Letter to Client, and you can do Attorney Fee Agreement at the same time. So let's see what questions are asked for those two documents. Well, here's the attorney fee. You put in your hourly rate and the hourly rate for your paralegal. And you could, if you're going to sign it before you send it, you could put in the date. You need to know the trustee in the case, and see you would pick from the drop-down, it's John Andrew Jones. There isn't a second trustee. Trust information, the date of the letter. That would be, of course, just the day you're going to send it. And that's really all you have to do. Let's see what happens when we click Create Documents. First, the attorney fee agreement. You save it. Oh, first, here's the attorney fee agreement, and it has your hourly rate in it. And you can just send this via email, or you could send it in the U.S. mail. And then here's the letter to the client. You might already have some of these documents, but you just have to edit it to reflect what's really going on here. And then get information. The client can fill in this. Now, of course, we also have the client interview form, which you could send as an alternate to get this information about the beneficiaries. And then there's a summary of the procedure that's going to take place during the trust administration. The next issue is the house at Gerhardt, which Jane, at her death, owned in her own name. This is a probate asset, but it's not necessary to go through a full-blown probate because with respect to decedents who have a will that is a pour-over will, where it's pouring into a revocable living trust of which they are one of the settlors, the monetary limits on the personal property and on the real property, which exist with respect to other types of cases where there is no pour-over will, which are limited, do not apply to assets that are being distributed pursuant to a pour-over will. It's unlimited. So it doesn't matter here that the property at Gerhardt is worth $1.5 million, even though for just a simple estate in general, the value of real property is limited to $200,000. So to go ahead and prepare a simple estate affidavit, what you would do is go review or update the probate app. Now, you notice there is a probate Olson Firm app here. Well, I added this earlier. And how you would do that is if it weren't here, you would go down to Select App, and you'd see that if it had not already been added, the probate Olson Firm app would be in this list, and you'd select it, and that would put it up here into the home screen here. Well, I've already done that. So now to go ahead and use it, you click Review or Update, and then you take a look at the documents that are available in the probate app, and one of them is the simple estate affidavit. So I've selected that by clicking on it. And once you do that, then the interview questions that follow are going to include the questions that are necessary to be answered in order to produce a simple estate affidavit in this case. Now, one thing that's important to remember is that in this case, Jane's trust, the John and Jane Jones Trust, is the devisee. So the template is going to pull from other important people. It's going to be looking for a person or an entity that is the devisee in this case. So you have to have the trust added as another important person, and it has to have a role of devisee, and it has to say, if it's a devisee, then the question is asked, what percent does it get? And in this case, it gets 100%. So you'll see when the simple estate affidavit is produced, it's going to bring in as the devisee the trust, and it's going to state that it gets 100% of the residue. Now, the other issue is what assets are subject to the simple estate affidavit. And again, you have to take a look at the assets and make sure that it is a probate asset. If you review all the assets that we entered here, you'll see none of them are probate until at the very end. Remember, we found out later that she, unbeknownst to us, we found out she did own something in her own name that should have been deeded to the trust while she was alive, but she failed to do that. So now it's a probate asset, and at the end of the probate, well, in this case, the simple estate affidavit is going to provide that the affiant, that would be the, instead of what they call the personal representative in a full-blown probate, the affiant, which is going to be John, is going to sign a deed on behalf of the estate, deeding the Gerhardt property to the trust. So you'll see here that the trust itself, if you open it up, you'll see for asset category, it's an Oregon probate asset. And who owned it was the decedent as an individual. Now, that's the only one on this list. If there were other assets that were going to be included in the simple estate affidavit, they would have to have that category of probate in order to be automatically brought in. So this is the only one that's going to come in. And then you need an execution date, which we're just going to call, you put a date in here and the state. And that's really all you have to do to create the document. So let's go ahead and create the document. And you see under the probate Olson firm, now there's a simple estate affidavit.docx. And what you would do is you're going to save that. And then you would, I already did it once, so I'm going to overwrite the existing one. And then you would download it. And I've already downloaded it. And this is what it looks like. So if you just review it, actually, I'm going to go back and do something else. I forgot to show you. There are some other questions in this. So let's go back again and open it up. And, if you hadn't answered, I've answered the questions already, but if you hadn't answered the questions, you'd have a bunch of errors in the document. And so here is the questions for this. You're asked if there's a will or not. Well, we answered yes. You're asked what is the court case number. Well, there isn't one yet. Once it's filed, the court will put a number on the affidavit. And the way this works, this affidavit gets filed and then it gets signed, and then the affiant can take that affidavit around, and they're empowered with respect to the assets listed in the simple estate affidavit. They're empowered to act as if they were a personal representative with respect to just those assets. So you want to make sure you have all the assets that you're having problems with that are subject to probate when you do prepare the affidavit. The questions are there's several questions here that have to be answered, like funeral expenses, safe deposit box, the signing date. Those are the three things that have to be answered, which I didn't answer before. Now let's go ahead and produce it again. So create the docs, save the doc. And and I've already saved it. So here's the document. I've already saved it. And if I'd failed to answer any of the questions, there'd be a bracket around the name of it, of the variable that I failed to answer, and you'd have to go back and run the template again and answer the questions. So you see, this is the form of the affidavit, and just to kind of review it here, this is all just stuff that this form actually is a form that's in the Oregon statute. And it's a form that is, I think they contemplate that just lay people are going to fill this form out. They're going to get it at the clerk's office. And so this template is based on that form. Now, some attorneys don't do this. Maybe they had a form in the past for small estate affidavit or simple estate affidavit before this form was created by the legislature. And so they prefer to use that, but just for simplicity, because sometimes the court clerks are picky about the simple estate affidavit, so probably a safer route would just be to use the form that they pass out, even though it has a lot of language that would make it appear that it's really not prepared by an attorney, that it's just filled out by a lay person. There's a lot of help in here that is given to the lay person to make sure they provide all the information that the statute requires. But this is just the form of it, and you'll see it's got let's go through it here. So it talks about the real property of the 2,000, but it says that the maximum value does not apply in this matter since the balance of the fair market value of the estate is attributed to property that is devised to the trustee of a trust, of which the decedent was a settler as defined by the statute, and which came into existence prior to the date of the decedent's death. And it's got the property. And so if there were other property, it would all be listed in here, either real property or personal property, and it just says there isn't any personal property here. But you could list other things like bank accounts or cars or things that, are titled in the name of the decedent when you prepare this. So that's basically this is the small estate affidavit. Now, like I said earlier, in this case, because it's real property, the property is going to be distributed to the trust by a deed signed by the affiant. And that's just going to be another asset that's going to have to be distributed pursuant to the trust agreement. And it would be distributed pursuant, as we just explored in the earlier part of this video, to the survivor's trust, which of course the survivor has the right to disclaim. And that's the topic we're going to talk about in the next video.